In this module, I gained insight into the complexity of employee classification, specifically the distinction between independent contractors and employees. This distinction significantly affects rights and benefits. For example, under the Fair Labor Standards Act, employees receive minimum wage and overtime, while independent contractors do not. Misclassification can lead to serious legal consequences for employers, including back pay and penalties, as highlighted in the U.S. Department of Labor's article, The Importance of Proper Classification of Workers. The gig economy has also spurred legislative changes like California's Assembly Bill 5, which seeks to enhance protections for gig workers. Additionally, the National Labor Relations Act protects employees' rights to engage in concerted activities, allowing even non-unionized workers to discuss workplace conditions without fear of retaliation. These insights have deepened my understanding of employment law and its implications for both employers and employees. One legal myth that surprised me is the belief that employees who are at will can be fired for any reason or no reason at all. While this is partially true, it is more nuanced than it seems. At-will employment means that an employer can terminate an employee at any time for any lawful reason or for no reason at all, but it does not give employers complete freedom to fire employees for reasons that are illegal. At-will employment does not allow dismissals based on discriminatory reasons, such as race, gender, age, disability, or religion, which are protected under federal and state anti-discrimination laws. Additionally, employees cannot be fired in violation of an employment contract for reasons that violate public policies, such as whistleblowing, or in retaliation for engaging in legally protected activities, such as filing a workman's comp claim or participating in a union. The surprising part of this myth was that people often assume the no reason at all part of the at-will employment means that any dismissal is legal. However, employees have protections, and terminations must not violate discrimination laws, labor laws, or public policy. Understanding that there are limits to at-will employment clarified how important anti-discrimination and public policy laws are in protecting employees from wrongful termination. This challenge to the at-will myth was eye-opening and demonstrated how often employment rights are misunderstood in casual conversations. Understanding employment law is crucial for companies and organizations because it helps mitigate legal risk and ensure compliance with federal and state regulations. Failure to adhere to employment laws such as Fair Labor Standards Act or anti-discrimination statutes can lead to costly lawsuits, fines, and reputational damage. By staying informed, employers can create a fair and legally compliant workplace, which is essential for fostering employee trust and maintaining operational efficiency. For example, the misclassification of employees as independent contractors can result in penalties, back wages, and tax liabilities, as highlighted by the U.S. Department of Labor. Additionally, violations of workplace discrimination laws under the Civil Rights Act of 1964 can expose companies to significant legal action and damages as outlined by the Equal Employment Opportunity Commission. These legal frameworks ensure that companies maintain a fair, inclusive, and legally compliant work environment, reducing the risk of costly litigation and promoting employee satisfaction. Two common approaches to agency law: the fiduciary duty approach and the contractual duty approach. The fiduciary duty approach emphasizes that the agent must act in the best interest of the principal, exercising loyalty, care, and good faith in all transactions. This duty requires the agent to avoid conflicts of interest and to act with the utmost integrity in managing the principal's affairs. The contractual duty approach focuses on the obligations arising from specific terms of the agency agreement, where both the principal and the agent are bound by their contractual promises, and breaches may result in liability for damages. This approach is often used to resolve disputes where the relationship is primarily governed by a formal contract rather than broader fiduciary principles. Both approaches can overlap, but the fiduciary duty is generally considered paramount when the agent is entrusted with discretionary powers or sensitive information. A real-world example of employment law in action can be seen in the case of Epic Systems Corp. v. Lewis, in which the U.S. Supreme Court upheld the enforceability of arbitration agreements that include class action waivers in the employment contracts. In this case, employees at Epic Systems were required to sign agreements that mandated arbitration of disputes on an individual basis rather than as part of a class action. The court ruled that the Federal Arbitration Act allowed employers to enforce such agreements even if it meant limiting employees' ability to collectively bring claims. The ruling has significant implications for businesses in structuring employment contracts, particularly in industries where disputes might involve numerous employees or claims of wage theft, discrimination, or other collective grievances. The factors influencing the employment relationship in this case include the employer's desire to limit legal liability and control the dispute resolution process, as well as the employee's ability to seek collective redress for grievances. This case highlights the tension between individual employment rights and business interests, particularly in the context of class action waivers. The impact of this ruling has been significant, as it allows employers to reduce litigation costs, but also limits employees' ability to challenge workplace practices on a broader scale. The decision underscores the importance of understanding the legal framework around arbitration and class action in employment law. Thank you so much for watching. This is Casey Cuevas, and has been my project content creator 4.